Good afternoon, and thank you for joining the Federalist Society at the University of Virginia School of Law for our third annual Originalism Symposium. My name is Rachel Daly, and I'm president of the Federalist Society chapter here at UVA Law. I'm honored to introduce a very distinguished panel to discuss originalism, institutionalism, and the Thomas Court. First, Judge Naomi Rao will serve as our moderator this afternoon. Judge Rao was appointed to the United States Court of Appeals for the District of Columbia Circuit in March 2019. She graduated from Yale College in 1995 and the University of Chicago Law School in 1999. Following graduation, she served as a law clerk to Judge J. Harvey Wilkinson III of the U.S. Court of Appeals for the Fourth Circuit, and in the 2001 October term, as law clerk to Justice Clarence Thomas of the U.S. Supreme Court. Between her clerkships, Judge Rao served as counsel for nominations and constitutional law to the U.S. Senate Committee on the Judiciary. In 2002, she joined the International Arbitration Group of Clifford Chance LLP in London, England. From 2005 to 2006, she served as Special Assistant and Associate White House Counsel to President George W. Bush. From 2006 to 2017, Judge Rao was a professor at the Antonin Scalia Law School at George Mason University, where she taught constitutional law, legislation, and statutory interpretation, and the history and foundations of the administrative state. In 2014, she founded the Center for the Study of the Administrative State, a nonprofit center that promotes academic scholarship and public policy debates about administrative law. In July 2017, she was appointed to serve as the administrator of the Office of Information and Regulatory Affairs in the Office of Management and Budget. She served in this position until her appointment to the DC Circuit. John Malcolm is the vice president of the Institute for Constitutional Government and director of the Meese Center for Legal and Judicial Studies at the Heritage Foundation, where he writes on a variety of legal issues. An honors graduate from Columbia College and Harvard Law School, John clerked for federal judges in the Northern District of Georgia and on the 11th Circuit Court of Appeals. For 10 years, John worked at the Department of Justice as an assistant United States attorney, an associate independent counsel, and a deputy assistant attorney general in the criminal division. John received numerous awards for his service, including the Director's Award for Superior Performance by an Assistant United States Attorney. From 2004 through 2009, he served as an executive vice president and director of worldwide anti-piracy operations for the Motion Picture Association. John then served as a distinguished practitioner in residence at Pepperdine Law School. From 2010 to 2012, John was the general counsel at the U.S. Commission on International Religious Freedom. John has also been actively involved in many charitable and civic organizations and was confirmed by the U.S. Senate in 2019 to serve on the board of directors of the Legal Services Corporation, the largest funder of civil legal aid for low-income Americans. Jennifer Mascott is an assistant professor of law at the Antonin Scalia Law School. Professor Mascott writes in the areas of administrative and constitutional law and the separation of powers. Her scholarship has been cited by the Supreme Court and has been published in the Stanford Law Review and several other journals. She is a former law clerk to Justice Thomas and to then Judge Kavanaugh of the DC Circuit, and testified in the Senate in support of Justice Kavanaugh's confirmation to the Supreme Court. Professor Mascott previously served as Associate Deputy Attorney General in the Department of Justice, as well as Deputy Assistant Attorney General in the Office of Legal Counsel. She has also held the positions of public member of the Administrative Conference of the United States and vice chair of the Judicial Review and Supreme Court Committee within the ABA's section of Administrative Law and Regulatory Practice. Professor Mascott also previously served as the faculty director of the Antonin Scalia Law School Supreme Court and Administrative Law Clinics. Professor Mascott graduated from the George Washington University Law School, where she earned the highest cumulative graduating GPA on record at the school. Beth Williams served as Assistant Attorney General for the Office of Legal Policy at the United States Department of Justice from August 2017 to December 2020. In that role, she served as the primary policy advisor to the Attorney General and the Deputy Attorney General, and as the Chief Regulatory Officer for the department. Ms. Williams also led the judicial nomination process for the department, assisting in the selection and confirmation of more than 230 Article III judges to the bench, more than any president has appointed in a single term since 1980. Prior to becoming Assistant Attorney General, Ms. Williams was a litigation and appellate partner at a national law firm where her practice focused on complex commercial, securities, and First Amendment litigation. From 2005 to 2006, Ms. Williams served as special counsel to the United States Senate Committee on the Judiciary, where she assisted with the confirmation of Chief Justice John G. Roberts Jr. and Associate Justice Samuel A. Alito Jr. to the United States Supreme Court. Ms. Williams is a graduate of Harvard College and Harvard Law School, where she served as executive editor of the Harvard Journal of Law and Public Policy. Thanks to you all for tuning in and to our panelists for being here today, and I will turn it over to Judge Rao.
Thank you so much, Rachel, and thank you to the University of Virginia Federalist Society for hosting this great conference on originalism. I'm pleased to be here to moderate this panel on originalism, institutionalism, and the Thomas Court. And it's a particular pleasure to be here with friends and former colleagues that I've known for many years. So today our panel is going to consider a variety of questions. The panelists will talk about some of the different variants of originalism. How do we think about originalism? How does originalism intersect with stare decisis? What institutional considerations are relevant when applying originalist methods? And how do we think of different understandings about legitimacy in the court? And I guess finally, what is meant by the Thomas Court? And is there really a Thomas Court on Chief Justice Roberts's court? So our format today is pretty simple. Each panelist will start us off with some brief opening remarks, and then we will have a moderated discussion amongst the panelists. And we hope that we will have a lot of questions from the audience. I know we can't meet in person for this great conference, but I encourage you all to raise your virtual hands and ask questions. And with that, we are going to have Beth Williams kick off this panel. Thank you.
Thanks so much, Judge Rao. It is so lovely to be here today with you and with the other distinguished members of this panel. And I also want to thank UVA Federalist Society for inviting me, and to Rachel and Connor for hosting this. So the panel today, as Judge Rao said, is really about looking at the future. What is coming next for the court itself, for originalism, and for judicial nominations generally. I'm going to frame my comments today with a few observations, and then I look forward to discussing more with the panel. So first observation is really about the originalism itself. And I think what we can see now is that for the foreseeable future, originalism controls. And what do I mean by that? Well, Justice Kagan famously said, quote, "We're all textualists now, and we're all originalists now." I think she said actually both of those sentences at two different times. And I think never has that been more true for the Supreme Court. And it's true for a couple of reasons. First, it's really been trending in that direction for a while. Even before Justices Gorsuch and Kavanaugh and Barrett, we had Heller. And obviously Heller had an application of originalist principles, both in the majority and in the dissent. We also had, from a statutory interpretation textualist standpoint, many other cases where the majority of the court explicitly stated that it's a settled principle of statutory construction that the text of the statute controls and that the statute must apply according to its terms. So why else is Justice Kagan's statement true? Well, it's also true that there's been a lack really of any meaningful limiting principle being propounded by non-originalists. Certainly true that originalism and textualism are not perfect, but they do have the trump card of bicameralism and presentment. And there have been really few compelling alternative theories of judicial interpretation that meaningfully and consistently restrict judges from imposing their own views on statutes and the Constitution. So I think one question that senators who care about limiting principles should ask in judicial confirmations is, what is your limiting principle? If you, the nominee, are not an originalist, if you are not a textualist, what is the principle of interpretation that is going to serve as a barrier, as a limitation to a judge, a future judge, just deciding cases based on personal preference? What's the limiting principle? So I think that's the second reason. The third reason that Justice Kagan's statement is true is that justices, I think, know full well that they, like the like the litigants, need to count to 5. And unless you are a justice resigned to crafting years of dissents, you need to persuade your colleagues that you are right. And when you have a majority of the Supreme Court now, or at least, a serious plurality who believes and has asserted that they believe in originalist and textualist interpretations, you're going to need those tools in order to convince your colleagues to rule your way. And so there's only obviously one real way to do that. So those are where I see kind of originalism now and the reasons for its ascendancy. My second observation is that despite the ascendancy of originalism, there are still really serious process arguments among the originalists and textualists on the court that need to be ironed out. And we saw that very clearly in the Bostock decision. And I know there was a prior panel about Bostock, so I won't go too deeply into that. But I think what you saw there is that one of the most interesting things about Bostock was the process. How did Justice Gorsuch and then how did the dissenters come to their conclusions? And I don't think this is what Justice Gorsuch would say he was doing, but he seemed to be taking a very administrative law approach to interpreting Title VII. And by that, I mean, he concluded that the phrase "because of sex" was unambiguous. He concluded that it unambiguously prohibited discrimination on the basis of sexual orientation or gender identity. And because he concluded it was unambiguous, there was no need, in his opinion, to turn to the original public meaning of the statute. He cited several cases, including the Carcieri case from 2009, which said that it's a settled principle of statutory construction that you first determine whether the statutory text is plain and unambiguous. And if it is, we apply the statute according to its terms. And he also cited the Germain case from 1992, both Thomas opinions, where the court said, we've stated time and again that courts must presume that a legislature says in a statute what it means and means in a statute what it says there. When the words of a statute are unambiguous, then this first canon is also the last. Judicial inquiry is complete. Justice Gorsuch then concluded that no ambiguity exists about how Title VII's terms apply to the facts before us. And because of that, it doesn't matter really how people understood the prohibitions on Title VII at the time. The words are clear. That ends the matter. Again, I don't think that he would describe it in that way, because I think he would say that the original public meaning was consistent with his view of things. But in the end, I think that's the process that he was taking. And that's really a very Chevron-like view of things, because if the statute is not ambiguous, then you don't need to defer to the agency, right? You stop there. If unambiguous, you stop there. Of course, there's been a general criticism in a lot of administrative law circles that courts are too quick to find ambiguity in statutes and punt to agencies, and that statutes are not as consistently ambiguous as courts would suggest. And I think Justice Gorsuch is very much in that camp. For him, there's also the benefit of consistency. He's unlikely to find many statutes ambiguous, whether they bear on administrative law or not. So then the larger question becomes, what is the order of operations in statutory interpretation? I think you've got several justices, including Justice Thomas, who authored the Carcieri and Germain opinions, who did not take Justice Gorsuch's approach. It seems like they would approach statutory interpretation more holistically, in terms both of looking to the semantic meaning of the words and the original public understanding of the words phrase at this time the statute was passed. Not that it's a 1-2 step, but that those two things go hand in hand. But the court's more liberal wing jumped right into Justice Gorsuch's opinion with no separate concurrences. So does that mean that we now have this 2-tiered structure where you first look to ambiguity before you look to original public meaning? And if so, how much does that undercut original public meaning? Will there be a rush to find that everything or quite a lot is unambiguous? If that's so, then I think under Justice Gorsuch's rubric, you don't have to worry about the difficult historical and messy questions of how things were originally understood. And if this order of operations holds, is this a big gift to those who don't subscribe to the original public meaning or originalist school? Is it a victory of textualism over originalism? So I think what to watch in the future is this a real split among the court's originalists, or is Title VII statutory interpretation aberrational? I think that's something that a lot of people are watching and looking toward. My third observation, just quickly, is about President Biden and judicial nominations. What's next? I think it's very important, and I don't think there's been much written about it, and I would defer to historians who could prove me wrong. But it seems that both President Biden and Vice President Harris are not only attorneys, not only both former senators, but they're both former members of the Senate Judiciary Committee. And again, I'd be surprised if this wasn't the first time in history that had happened, and we've had such a combination. President Biden, of course, was the former chair of the Senate Judiciary Committee. And so they are no strangers to judicial confirmations and all that goes with them. They're keenly aware of judicial issues, and they're very much attuned to the battles that are related to them. So I think that you're going to see judicial issues be prioritized. The second point is that there was a criticism of President Obama's delay on nominees, especially in the first year of his presidency. They did not get off to a swift start. What you have here is the recent announcement by the Biden administration that they are not going to allow the American Bar Association a pre-clearance role in their judicial nominations process. This is very significant because in recent history, the two former Republican presidents, President George W. Bush and President Trump, both said that the ABA would play a role but would not play a pre-clearance role in the nomination, where President Obama said, no, the ABA is going to pre-clear before we announce any names. And that was, many people think, part of the reason that they were slow going at first, because the ABA has a very thorough process. And so not allowing the ABA to play a pre-clearance role will probably allow President Biden to get more of a jump on getting nominees out more quickly. The other thing that you're probably going to see is that there's going to be a focus on diversity of experience. There are a lot of forces that are pushing President Biden to look not only at traditional, law firm partners and former prosecutors, but to look very carefully at legal aid, people who were public defenders, people who were legal activists, academics, to have a greater breadth of experience. And the two last things, one, the Chairman Durbin and the blue slip, what will happen there? Senator Durbin was one of the few Democratic senators to have really engaged in meaningful negotiations and good faith negotiations with the White House over judicial nominations. And that really worked to everyone's advantage, because Illinois had very high quality nominees with strong bipartisan support. And he was also very critical of getting rid of the blue slip for circuit court nominees. So it'll be interesting to see if he sticks to that, if he thinks it's not appropriate to go do away with the blue slip for circuit court nominees, or if he's going to stick to the precedent that was set by Chairman Grassley and Graham. Finally, Senators Manchin and Sinema, I think, are the ones to watch. I think the question for them is really, is there going to be any nominee from this president who they will not feel comfortable supporting? Because it looks like the only vulnerability for President Biden's nominees will be on the floor. So with those observations, I will turn it over to John.
Thank you, Beth. It's delightful to be here. I want to thank the Federalist Society. I'm only sorry that we can't be in person together. So the write-up for this panel, this panel promises basically to address three things. The first is, what should originalists expect in the coming years? The second is, who will be the intellectual heir to Justice Scalia? And the third is, how will President Biden reshape the judiciary? Let me address all three of these briefly. So first, what should originalists expect in the coming years? It's somewhat ironic to me that there are all of these challenges to originalism from the right. You just had a panel on that, and this is being led primarily by Harvard law professor Adrian Vermeule. It's ironic that these challenges are coming up just as another clearly committed originalist has joined the court. Nobody thinks that originalism is perfect, and even committed originalists like Justices Thomas and Scalia occasionally disagreed with each other in particular cases. However, as Justice Scalia said, people who defend originalism don't have to prove that it's perfect. They just have to prove that it's better than all of the other suggestions. And in my opinion, originalism clearly passes that test. From my perspective, unless the Democrats succeed in packing the court, which is something that I'll address in a few moments, we may be entering a relative golden age of originalism. And I think that is a good thing. Second, who is going to be the intellectual heir to Justice Scalia? Well, the title of this panel suggests that although John Roberts is the Chief Justice of the court, that this is now really the Thomas court. And I tend to agree with that. I think that Justice Thomas can rightfully claim the mantle of being the intellectual heir to Justice Scalia, although I, for one, am hoping for a very robust competition for that title among some of the newer justices on the court. Justice Thomas has never been a faint-hearted originalist, as Justice Scalia once labeled himself. He shows the least deference to stare decisis, preferring to revisit precedent in constitutional cases, since the court is the only body, short of a constitutional amendment, that can correct its past errors and adhere to the Constitution as it was understood by the people who ratified it. He has expressed interest in revisiting things like the exclusionary rule, the scope of the Commerce Clause, the free exercise and establishment clauses, whether the privileges or immunities clause of the 14th Amendment is a dead letter, and many other issues that have been considered for a long time by many to be untouchable. Another factor is that if you include concurrences and dissents, Justice Thomas simply writes more opinions by far than any other justice. So last term, for example, Justice Thomas wrote 31 opinions, followed by Justice Alito with 24. The year before that, he wrote 28 opinions, followed by Gorsuch with 22. The year before that, he wrote 31, followed by Justice Sotomayor with 23. And the year before that, he wrote 31, followed by Justice Alito with only 18. I could go on, but you get the idea. He is not afraid to express his ideas in any case. And over time, that has influence. Many of Justice Thomas's former clerks have now become influential academics, policymakers, and judges themselves. Two of them, of course, Judge Rao and Professor Mascott, are on the virtual stage with me right now. But I could name many, many more, including some that have already spoken today at this symposium. Another thing is that as the most senior judge on the court, Justice Thomas gets to assign majority opinions when he is in the majority and the Chief Justice isn't. And that can have a huge influence on things. One of the few benefits, by the way, of virtual arguments, but it is a big one, is that Justice Thomas is now asking questions. And since he goes second, his questions now often set the tenor of oral arguments as other justices play off of the questions that Justice Thomas has already asked. In short, Justice Thomas's influence looms large over the court, and I think it's going to continue to do so for quite some time. Third, what comes next in the judicial wars and what will happen under President Biden? President Biden has called for the creation of a commission to study the courts. The commission will last for 6 months. And he has suggested that, and this is a quote from him, things are out of whack with the courts, although he doesn't say how they are out of whack. So President Trump appointed 3 Supreme Court justices, 54 circuit court judges, and 174 district court judges during his time in office. That is a lot. Still, President Obama appointed 1 fewer Supreme Court justice, 1 more circuit court judge, and 94 more district court judges than President Trump did. When President Trump won, you didn't hear any Republicans saying that the courts were out of whack and that they somehow needed to be studied. Many judges who were appointed by Democratic presidents and who were eligible to take senior status during President Trump's presidency held on, hoping that Biden would win. They will now all take senior status, giving President Biden the opportunity to name their replacements. That process has already started. over 24 judges have already announced that they are taking senior status since President Biden won. Plus, once Merrick Garland is confirmed as Attorney General, Judge Rao is going to get a new colleague. President Biden is going to have the opportunity to name another judge on the highly influential DC circuit. The establishment of this commission is not only a solution in search of a problem. In my opinion, it is a very dangerous development. But it was presaged by remarks that were made by some Democratic senators. So in August of 2019, 5 Democratic senators filed a legal brief in the Supreme Court in a Second Amendment case out of the Second Circuit. The brief was written by Senator Whitehouse of Rhode Island. It was joined by 4 others, as I said. 4 of those 5 are senators who sit on the Senate Judiciary Committee. The brief ended as follows. They said, "The Supreme Court is not well, and the people know it. Perhaps the court can heal itself before the public demands that it be restructured in order to reduce the influence of politics." President Franklin Delano Roosevelt said something very similar, by the way, in a fireside chat in 1937. He said the Constitution needs to be saved from the court, and the court needs to be saved from itself. And he did that at the same time that he offered his court packing plan. That plan was roundly rejected, even though Democrats controlled substantial majorities in both the House and the Senate. They saw the court packing plan for what it was. In March of 2020, as the Supreme Court was about to hear arguments in an abortion-related case, Senator Chuck Schumer, speaking on the courthouse steps, said the following, and the video of this has been played, I think, 3 times already this morning at the impeachment trial. He singled out Justices Gorsuch and Kavanaugh, and he proclaimed, "You have released the whirlwind, and you will pay the price. You will not know what hit you if you go forward with these awful decisions." Others are more blatant about their goals. The group Take Back has said, "Congress must add seats to the Supreme Court in order to, quote, restore the right to vote, ensure reproductive freedom, halt our climate emergency, and save democracy." For them, court reform is all about manipulating the judiciary in order to deliver political goods. This should be seen for what it is, a naked attempt to manipulate the judiciary to produce decisions that fit a particular ideological or political agenda. The court should never be a partisan political actor that is completely dependent on the will of the political branches. The crisis is simply that the left doesn't like some of the Supreme Court's decisions or many of the recent judicial appointments. But not getting your way every time is not a crisis. Judicial independence is literally one of the reasons why we fought in the American independence. Among the Declaration of Independence's list of grievances includes that King George was manipulating the courts. Once one party packs the court, it will invite tit-for-tat retaliations when the other party takes powers. And while many view the court as already acting in a political manner, things could get much, much worse, in my opinion, if it is reformed by the political branches. Let's hope that doesn't happen. Now let me cede the floor to Professor Mascott.
Well, thank you so much, John and Beth and Judge Rao and the UVA Federalist Society for having us today. And I'm particularly thrilled to be here talking about originalism, institutionalism, the Thomas Court as a former Thomas clerk. I take the provocative title Thomas Court to be coming from the idea that now that we have 5, with the confirmation of Justice Barrett, 5 perhaps originalist or at least more conservative members of the court, that the idea, and the chief not being among them, that the idea is now Justice Thomas is the most senior originalist and conservative, will have more majority opinions that he can draft, assigning them to himself or to others in contentious cases, and the court will continue on an unbridled sense toward an originalism in a more pure sense. And I have to say, unfortunately, I'm not sure that it's so clear that things will move in that direction, perhaps as much as some of us might like. For one, I think whether it's because cynically you think that originalists don't necessarily always stay with their methodology in a given case, or whether you think originalists are so principled that they are willing to follow the methodology even where it leads them to a result that they don't like. It seems to me that often the 5 originalists or conservatives do not necessarily, we can't necessarily expect them to stay together in a voting block. And so, for example, even though it was an originalist case, we sort of saw this last night with Justice Barrett joining with the more progressive justices in the death penalty case, and being willing to not to continue to have the bar on the execution because of the lack of the presence of the clergy member that the to be executed individual wanted. And so she sort of peeled away and did not go the way that maybe some of the other more conservative justices you might expect. So I think that would mean that we won't necessarily have that conservative originalist majority in particular cases. And even when we do, I think that the chief has indicated, or it seems like from past practice, he may very well decide to, if he's comfortable with it, be in the majority in that case and write the opinion then in a little bit more narrow way if it's a 6-3 majority, much like we saw his predecessor, Chief Justice Rehnquist, do in certain cases over the year. That said, like John Malcolm, I don't actually think that that necessarily means that this is not the Thomas court, because Justice Thomas, I think for decades, has been an intellectual leader and often the key intellectual leader on the court already. And it's not necessarily because of the flashiness of having a name on a given majority opinion in a given case, but as John pointed out, that Justice Thomas often, or has at least in the past, written the most opinions in any given term, if you count concurrences to dissents, often the most pages. Jan Crawford's book a while ago showed that Justice Scalia also, of course, was a strong originalist, strong intellectual powerhouse. But at the beginning of his service, Justice Thomas was even in certain ways behind the scenes, sort of joining with Justice Scalia to pull him a little bit more to the right or more to the originalist view in certain cases. And then also, as John said, former clerks having roles as judges too on the DC circuit, just under the Trump administration. And then other things that people don't necessarily think about as much with Justice Thomas, I think he's had a large role in shaping the minds of students. He's incredibly generous with his time, having for years taught a course on the Constitution at GW Law School, teaching with Judge Rao, and now I've been the beneficiary of his course, History of the Administrative State at Scalia Law and other places. And so he's taking the time to shape the minds of students, changing the terms of the debate. Folks now, when they're briefing cases before the court, are much more apt to brief originalism, textualism, and historical issues. And then also, I think with Justice Thomas or even others behind the scenes, it can often be hard to measure the metric of a justice's influence based on just which opinion they do or don't sign, because there's so much negotiating that goes on behind the scenes, or even editing of opinions where maybe a certain justice was going to write a concurring opinion, but instead of seeing that happen, the drafter of the majority opinion changed what he or she was going to say to accommodate the other view, or took out something that was otherwise not going to be able to get a majority view. So I think Justice Thomas has been the intellectual leader and will continue to do so. As far as whether there will be this majority originalist approach, as I said, I do express some skepticism that folks will always come down in the same way on that, even among the originalists, to give us a pure originalist majority. And there are a couple of reasons for that. One, so if we take justices who we might think of as more theoretically purely originalist, or who have expressed a commitment to that, maybe Justice Thomas would fall into that camp. Justice Gorsuch, maybe we would think, would fall into that camp, although I think Justice Thomas has been the most consistent out of the bunch. But sometimes originalists in applying their methodology do end up seeing things factually a different way, like we saw in the oil states case. Even if we get the theoretical justices together on originalism, others who have expressed commitment to originalism include folks like my other former boss, Justice Kavanaugh, who definitely his confirmation hearings expressed a commitment to originalism, but he talked about it in terms of kind of suggesting that it was sort of similar to the Justice Kagan view, we're all originalists now, we have to consider it. But for him, I think that includes the text of the Constitution, it includes original public meaning, but it suggested he thinks that's going to mean looking at historical practice. And he's also said that he believes stare decisis is actually built into the proper Article 3 role of a judge. And so he may rely more on stare decisis than others. And again, if you read the separate opinions, there weren't a lot of pages of them last night in the execution case. He reached the same outcome as Justice Thomas, but he took the time to write separately to really express quite an institutionalist pragmatic view where he thought the execution should move forward, but he really wanted to make it clear to the states that to make things work well and to save a lot of time and a lot of consternation, it would just be better off if in the future they just let clergy members in the executions in the first place. And so you can see that kind of institutionalist, or let's make sure everybody's doing what works along with being right, bent to his approach. And then Justice Alito has not spoken as much about originalism. I have heard him publicly say he's a supporter, but how theoretically committed to it, I think he tends to line up more with Justice Thomas and Justice Gorsuch than some of the others, but is not necessarily, I think, always going to go as far as Justice Thomas. And then Justice Barrett, I think, will be the most interesting to watch because we do think of her as committed to originalism, but her writings before taking the bench at the Supreme Court, at least when she was describing the role of her former boss, Justice Scalia, and how he saw stare decisis and the role of a justice, is she would, I think, suggested that you can be methodologically pure as an originalist, but not necessarily have to uproot lots of precedent and lots of cases. And so she talked about what she thought as very legitimate means of having more limited rulings in cases. How judges rightly are just deciding cases in controversy. And so if a litigant, if to resolve a litigant's case, it's not important to go back and uproot a lot of precedent. It could be very legitimate, at least according to what the views she's expressed in her writing, to take a more limited approach and just answer the case before oneself, maybe extend precedent any further, not reach the wrong outcome, but also it's not necessarily required in every given case to go back and revisit all of the legal principles supporting the decision. I think she also implied that it's appropriate use of your vote on a cert petition, whether to grant or not grant cases based on how much it's going to uproot precedent. And I think, so Justice Thomas himself has actually expressed somewhat agreement with, I think, Justice Barrett on the first question, in that you'll sometimes in opinion see him say, if the parties had asked us to, I would go back and reconsider whether all of the principles, undergirding this precedent or the question before us need to go back and be revisited. But I'm not going to necessarily do that here because the parties haven't asked us to. But I think Justice Barrett then seems to go another step and suggest that maybe even if a party's asking to, that there might sometimes be instances where that would mean the court should not take the case because it would be too destabilizing to take the question and reach the right answer as an originalist matter. And folks like Justice Thomas, I think, have suggested almost that they would be more comfortable to grant certain such cases and go back and revisit, decades or more worth of precedent. And so I am very encouraged that originalism, I think, is here to stay. People have to deal with it and contend with it as a methodology. But I do think there are going to still be a lot of surprises, so to speak, from those of us who are used to thinking about things from a more Justice Thomas, what's the Constitution say? Let's get there more quickly, as the justices who have expressed a commitment to originalism has very different ways of how far they're willing to go in any particular case and apply the methodology to the dispute before them.
Great. Thanks so much, Jen. I'll invite all the panelists to turn their cameras back on. Great, thanks. Thanks to all of you for your remarks. So I would just remind the audience, we are open for Q&A if you want to send us any questions, but I have some questions for the panel. So it's often the case that questions about originalism and questions relating to how far we should go with originalism, how do we weigh originalism against competing concerns of stare decisis, those questions are often tied to what people sometimes call the legitimacy of the court, right? How legitimate is it for judges to follow originalist methods or to overturn precedents that might be around for a long time? And so I'm wondering if you could each maybe address this question about legitimacy, right? Should we be concerned about the legitimacy of the court, and what version of legitimacy do you think is important for the court to have?
Well,
John?
Since someone's jumping in, I guess I'll jump in. Look, I was very interested when Jennifer was speaking about her views on mentioning stare decisis, because I do think that that's, even among the originalists, I do think that their views on stare decisis will be very, 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 very different. I mean, so a stark example of this was Chief Justice Roberts's concurring opinion, or maybe, no, I think it was concurring opinion, the June medical case, in which he said he'd come out the other way on the exact issue in Whole Women's Health versus Hellerstedt 2 years beforehand. And he wrote a concurring opinion that said, I believe everything I said in Whole Women's Health versus Hellerstedt. I think the result in this case is actually wrong, but I'm going to concur in the judgment because I think it will challenge the legitimacy of the court if all of a sudden we are reversing a precedent when the only thing that has really tangibly changed is the personnel of the court with the replacement of Justice Kennedy by Justice Kavanaugh. I mean, look, I tend to be more of the Clarence Thomas school, which is to say, the Constitution is the supreme law of the land. It is the charter that governs us and sets limits on within or among the three branches of the federal government and between the federal government and the states, and even places limits on both the federal government and the states vis-a-vis our rights and liberties as individuals, and that the only way to get something corrected, if the court doesn't correct itself, is via a constitutional amendment. Very, very difficult thing to do. But I'm not an idiot. I recognize that if somebody came forward and said, for example, that passing the Social Security Act would somehow violate the Commerce Clause, I'm just making it up as an example, and you would undo by reversing that so many settled expectations that people have come to rely upon, that would be foolhardy. I mean, the middle course is what I think you see Chief Justice Roberts use on occasion, which is a minimalist approach, saying this far but no further, or chipping away at precedent that he doesn't like by finding exceptions and fitting them in until at the end of the day, the precedent is narrowed down to something either more manageable or perhaps unrecognizable, depending on which side of the political aisle you happen to be on. But that is a very interesting question. I tend, since the court is the only body that can interpret the Constitution and amend its own errors, to be a little bolder, but I realize that the decisions that those 9 make have an awful large impact on an awful lot of people.
I mean, for my part, I'm not sure that I see legitimacy itself like as an independent value that is part of the judicial role. I mean, John is sort of talking, I think, maybe about obviously like when should the court revisit mistakes, but sometimes when people talk about legitimacy, I think it's used more as a cover or euphemism for how is the public going to perceive the court, or are we going to be thought of well or taken seriously? And I do think that there are some members of the court who seem to believe that that is an appropriate part of the judicial role, and have told us even sometimes in their confirmation hearings that they embrace that value. But I have not seen that persuasively grounded it at all in what the Article 3 role is to decide cases and controversies. So I would sort of say legitimacy in and of itself is not really a thing. And then the second point, I guess, is, since John mentioned the Commission on Supreme Court Reform before, and folks have been talking about this for a couple of years, interestingly, ever since Justice Kavanaugh was confirmed. So I distinctly remember talking a lot about that process leading up to his confirmation. And then as soon as he was confirmed, getting requests to now talk about whether the Supreme Court was legitimate. And, I just think that if the court were doing fewer things and stepping in less century, that maybe the eyes would go elsewhere. And that is ideally what I think we would like to see happen, is again, more of an understanding of the courts as adjudicators of cases and controversies, not as policymakers. And we just don't need commissions to reform the court. And we need really the political branches to take more of an active role and come back to a little bit more constitutionally, historically grounded balance with Congress policymaking, and the executive carrying that out in a little bit more limited, constrained fashion.
Yes, maybe legitimacy is about just following the law.
Okay, I agree. That sounds good to me.
I actually think that when the court, as on occasion majorities will do, twist things or bend things to try to reach a result that they think will be more acceptable to the public because it is concerned about its legitimacy. When it does that, it harms its legitimacy more than anything.
Yeah.
Beth, any thoughts? Having
No.
put on a lot of judges who hopefully are maintaining the honor and legitimacy of the Article 3 courts.
No, that's right. Look, I agree with everything that's been said. I think that the term legitimacy seems to always come up when you disagree with court decisions that are coming out, right? If I disagree with them, then therefore the court must be illegitimate. But I think that one of the great things about Justice Scalia is that you saw sometimes his originalism lead him to results that he would not have voted for were he a legislator. And that more than anything else should bolster legitimacy. Not that legitimacy is somehow like a factor in your opinion making as a judge, but when the public sees that, when they see appointees of Democratic presidents maybe joining with other judges of Republican presidents where the end result is a conservative outcome, that increases legitimacy. You don't see that quite as much maybe as a conservative peeling off here or there, but if you have a consistent judicial philosophy, you're going to try to reach the right answer regardless of whether you would agree with the political outcomes if you were a legislator.
Okay, we have a couple of questions here, including one from Doug Maggs, who is, I will say, a Justice Thomas Grand Clerk, his father having clerked for the justice. So Doug Maggs has this question. Who do the panelists suppose is the ideological center of the court now? Still Chief Justice Roberts, or perhaps now Justice Gorsuch, Justice Kavanaugh, Justice Barrett, or perhaps do we not really know yet? Interesting question.
Yeah, I can start off with that. I think you're going to see a lot of shifts. Honestly, I don't think that there is going to be a very clear center person, because I think that as Professor Mascott said and John said, the approaches to stare decisis among the court members are very different, and you're going to see that kind of ebb and flow with different cases and with different facts. And so, I bet you're going to see a bunch of cases where Justice Gorsuch and Justice Thomas are together. And then, like in Bostock, you saw that they were not together. I don't think that I think it's going to be a lot of movement. There is, I think, though, a more clear institutionalist versus or I guess the justices that take institutionalism into account maybe more than the other justices. And I think that's where you probably see the clearest split. I wonder if Justice Kavanaugh and Justice Roberts, I think, more publicly take that into account.
So it was easier, I think, to have that conversation when when everyone sort of thought, well, okay, you have the 5 quote unquote conservatives most of the time and the 4 quote unquote liberals. Now that it's 6-3, it's a little bit tougher. And it'll be very interesting to see which way Chief Justice Roberts goes, whether he, becomes, from the conservative perspective, a more reliable 6th vote than he was a 5th vote, precisely for no other reason, because the court's going to do what he's going to do, so he feels more comfortable expressing his views rather than the institutionalist view that he had. And the other, equally, if not more important, is that if he's in the majority, he gets to write the opinion or assign the opinion. Before that, while everyone said Kennedy and Roberts were the swing justices, and I think that they were, I could have named you for literally every justice, including Justice Thomas, a 5-4 opinion in which one of the conservatives split off with the 4 so-called liberals to form a majority. If you're curious about the Justice Thomas case, it was the Texas license plate case that involved Choose Life or the veterans or something like that. But Justice Alito, all the ones at one time or another peeled off. It's going to be harder, I think, for Justices Breyer, Kagan, and Sotomayor to do that, but not impossible. They did that the other day in an opinion written by Justice Sotomayor that was joined by the Chief Justice and by Justice Kavanaugh. So it's going to be difficult to say that there is a center of the court now since it's going to take two centrists to cross over, whereas before it only took one.
Interesting. Jen, any thoughts?
Yeah, I think, I mean, I think I mostly agree. I think it is likely, I don't know if I would call it the center in terms of where the view is going to come down, but I do think the chief, I mean, he seems to believe that institutionalism and making sure that the court is respected and playing its proper role is a core value. And so I think because of that, at least it seemed to me that it seems as though he's very cognizant, especially with more and more conservative members that get on the court, with the court not swinging too much one way or the other. And so I think whether it's John's talking about, it's when he's the sixth vote, trying to narrow the opinion and have it be more incrementalist, or whether it's the fact that I agree with John, there are many cases in which we're going to have somebody peel off. And maybe it's somebody joining the so-called liberal view, or maybe it's just a case where because of somebody's methodological approach, such as Justice Thomas, for example, on preemption, and not finding federal preemption as readily as some others, sometimes that leads to policy outcomes that are a little bit more liberal. So whatever your issue is, there's just a number of cases where the five conservatives are idiosyncratic in something, and they're going to be joining the other block. And I think in those cases, it wouldn't be surprising to see the chief jump on as well, and then be the fifth vote on whatever that side is, having it be narrow in the other direction with the more liberal justices. And so maybe that means he's in the middle. I also wouldn't be surprised if there aren't a lot of like alliances or other sort of maneuvering behind the scenes, trying to figure out where people are going to go on certain opinions. And the chief playing a role that way as well.
Great. We have some other questions, which I'll turn to. We have one from Nicolo Beltramo, who asks, speaking of legitimacy, there are sometimes discussions about switches in time on the court, especially with regard to the NFIB versus Sebelius case. Are switches in time where justices vote contrary to their best reading of the law out of concern for societal perceptions legitimate? And perhaps more importantly, are they consistent with the constitutional and judicial oaths of office? And finally, what follows from our answer to those questions? It's a multi-part question, I guess.
I'll jump in. I mean, yeah, so I was thinking of NFIB versus Sebelius and also King versus Burwell before, when I talked about, when the court bends language to try to reach a result because it is concerned that there will be an outcry from the public, and there is this concern about the court's legitimacy, that it does more to damage the court's legitimacy to any real serious lawyer. And so I'll single out Chief Justice Roberts. I have respect for Chief Justice Roberts, but in his confirmation hearing, he said justices should not be players in a game. They should be the umpire calling balls and strikes. And there have been on occasions in which I have not quite seen that in practicing what he preached. And I think in the long run that does more harm than good. I mean, there's a reason why we have the political branches of government, and they are designed to hash stuff out. And the judges have a limited but incredibly important role to interpret the law and apply the law to particular facts and actual cases and controversies. They should stick to that. And if they want to have, as Jennifer was mentioning before, and she talked about a Kavanaugh opinion in which he was engaging in an ongoing dialogue with the state prison authorities. If the justices want to have an ongoing dialogue with Congress and the presidency and state legislatures, I think that is fine. But at the end of the day, that dialogue should be, don't throw your problems into our courtrooms, solve them yourselves.
Yeah, I would just say that exactly underscores the reason why I think folks who are nominated to be judges really have to be able to enunciate a judicial philosophy that they will adhere to as they're going forward. Because if you don't have a consistent judicial philosophy that you've thought about before you take the bench, I would imagine it would be much easier to say, well, I will call them like I see them. You know, what is justice in this case? How am I going to approach this case without, really having internal consistency, or with there being, values in the ether that may come into play in different cases. That is important for the legitimacy of the court, right? Whatever your judicial philosophy, you should be consistent and you should stick to it.
Yeah, I think that's right. I don't think concerns about, how the court's opinions are going to be perceived or how much uprooting it's going to do really legitimately come into play, particularly when the question is before the court. They've got to answer it based on the law, based on the Constitution. One of the things I found interesting, and just to keep maybe going back to her as an example, because she's the newest member, is in Justice Barrett's writing, she actually even takes issue with Justice Scalia's reference to himself as a faint-hearted originalist, and says even there, suggests she's uncomfortable with seeing stare decisis as being an exception to when judges are supposed to do the right thing. And so again, she says there might be some legitimate ways we can cabin things. We don't have to get to every nook and cranny of every subsidiary legal issue leading to the precise question that's been briefed before the court. But when we're talking about answering the question we're considering, that, theoretically speaking, we've got to basically be coming out with the right answer, because otherwise it's really hard to understand what the constitutional role is for just sticking with something that somebody knows is wrong and is not consistent with the law or with the text of the Constitution.
Okay, I have another question here from Michael Potter, who says, I share Professor Mascott's skepticism regarding the extent of change now. We have seen Republican appointees drift center, and there's a lack of agreement on stare decisis' proper role in self-avowed originalist judicial restraint jurisprudence, see Ramos and Gamble. And then I'm just going to kind of summarize this question, which is essentially that while originalism has grown to be a more legitimate force, is it better to try to resolve disputes about originalism within academia or on the bench? So we have some academics, quasi-academics.
I've always seen academia and the bench as having a robust, ongoing dialogue on discussions like that. And I don't see that as, judges should say, don't bother me, don't bother putting in your brief or talking to me about originalism. That's for academics, or vice versa. I think that there are great academics on originalism. You're seeing new people coming up with things like corpus linguistics to try to get better answers on originalism. And I think anything that contributes to getting the right answers is a good thing, regardless of whether it's a judge who comes up with the best methodology or an academic somewhere. That's how I see it.
I think they're very much going to have to work hand in glove, the judiciary and academia, because, for originalists, judges don't have the time to do deep originalist research all of the time, right, on their own. They don't necessarily have the resources there. They don't necessarily have the time, especially, on courts that are not the Supreme Court. And so there is a huge opening now, I think, for originalist legal academics to produce writings and articles that are very helpful and very directly relevant to a lot of the issues that are going to come before us. And I think that you're going to see judges and justices looking to those more and more.
Right, like articles Professor Mascott has written and have been cited by many courts. So.
Well, that's nice for you to say. As an academic, I would like to think we have a role. I do think, Professor Barnett is kind of echoed Beth's point about, academics should take the opportunity to try to, we've got the time to sort of unfold the court's understanding, particularly about history. I do think, at least to date, the originalist scholarship tends to be in academia a lot very heavy on the methodology. And so I'm trying to kind of be accountable myself and encourage colleagues to write more about the content and the substance of what the provisions mean. But knowing the time that it takes and the length of articles that one might write if they're trying to unpack the meaning of even just a few words, there's sort of, there's some institutional, unfortunately, with like tenure and length of articles and time, institutional, I think, hurdles to folks writing about what the Constitution actually means rather than trying to figure out how we should all approach what it means. But I do hope that we all spend more time trying to work on the substance as opposed to just debating about the around the edges about the right methodology.
Okay, we have a question here from Austin Lipscomb. There was a mention of originalism acting as the best equipped limiting principle to prevent ideological-based decisions. However, given the broad and highly interpretable nature of the Constitution, is there not a risk that members of the judiciary may impose a biased understanding of the law and undercut that limiting principle, i.e. the possibility of the majority and the dissent in Heller basing their adjudication in originalism? And I guess I had a related question to that, which is it really optimal for us all to be originalists now or all to be textualists now? Does that just allow the methods to be used to reach particular results and thus, undermine what I think people view as one of the advantages of originalism and textualism is their certainty and their relationship to the rule of law?
I'll jump in. I'm not meaning to be rude. I guess I'm just not shy. So I've been intended to go first. Look, originalism's not easy. It's not like you put it into a machine and it turns out an answer. And so, people on the left have said, oh, well, the reason you like originalism, it ends up leading to results that you like. There are people who do originalism well and people who do it badly. I mean, if you were intent on manipulating a system, I suppose you can do it, but at the end of the day, it's going to result in a written opinion, which can be reviewed and praised or criticized. And I guess what I would fight back against that is, I forget whether it was Beth or Jennifer who said that, was, to cite Justice Scalia. I mean, Justice Scalia was a proud law and order guy who was known on the bench as the criminal accused's best friend, because he took things like the Sixth Amendment right to confrontation seriously, and he wrote Fourth Amendment opinions like Kylo, and that took these protections seriously, even though it sometimes resulted in some very, very bad people getting off. He was quite the patriot. I don't think anybody would ever accuse Justice Scalia of being unpatriotic. He joined an opinion by Justice Stevens that said that flag burning was protected by the First Amendment. And he did that by approaching originalism seriously and with fidelity. And, that doesn't mean I agree with every decision that he ever came out with, but it was certainly not, an ideologically based opinion reaching a result that he liked.
Yeah, I mean, look, there is a value to more people trying to figure out what the understanding of a term was at the time the legislature passed it, right? What was because that's how democracy works. Those are the people who were there, who understood what a meaning would have been at the time that Congress passed it and the president signed it into law. And that's the most democratic way to read the law, because those were our elected representatives at the time the law was passed. And so if you have more people doing that, even if they come to different conclusions based on historical texts, I think there's still a real value in, a diversity of people engaging in that exercise.
I agree. I mean, and also I think just institutionally, we want to make sure that we highlight the legitimacy of the role in the first place. I mean, everybody wants to talk about with originalism, the places where it's contested, where the evidence isn't clear, but obviously the Constitution does have some just clear bright line principles apparent from the text. Also, even when you get into more fuzzy or less clear questions that are answered, oftentimes there are at least areas that are answered or walled off if we understand the history. And so I think to the extent that there's sort of a general acceptance that originalism is a good or the best methodology, at least on those areas where it's more clear cut, maybe people will feel they have to follow it. I do, though, as the others have mentioned, think it is going to require people engaging in good faith. I mean, sometimes people are engaging in so-called originalist research, I think, to find the gotcha examples like, oh, this approach can't be right because we found one or two counterexamples. Well, that's fine. It might be helpful to know, but then hopefully you're going to pursue and figure out then what the right alternative historical answer was. hopefully there will be more than one study on any given phrase. And then as there's a great marketplace of different studies being done, we can sort of sort through those, I think, and together figure out where we've gotten it right and then where we still need to do more work and more digging.
Yeah, and let me just add one other thing, which is, I harken back to something I said in my opening remarks, which Justice Scalia said, what is the alternative? The alternative is if you have 9 lawyers in robes, what I think 8 of them went to Ivy League schools, most of them came from the East Coast, making these decisions just for what they, not what's in the Constitution, or how, it's like what they think ought to be done. That is primarily, so long as you're abiding by proper separation of powers, what ought to be done, unless it's clearly enshrined in the Constitution, are decisions that are left to the people and their elected legislators.
I'm glad to hear that you three are so optimistic about this question, because I guess I have a concern that bad forms of originalism and textualism may undermine the methodologies as a whole. But you all are very optimistic that as long as enough people are doing this, sort of the right answer will eventually come out. So I hope that's true.
They have to do it with fidelity, and they have to be smart enough to do it right. And, certainly very much present company accepted, there are some bad judges out there who just do a shoddy job.
Okay, good. It's always good to be optimistic. That's very important, actually, in life. Otherwise, this is just very grim. Okay, so we have a question from Christopher Baldacci. One of the hallmarks of the Warren Court seems to be the fact that when it had a liberal majority, it voted as a liberal majority in most major cases. But I wonder if this has set an unrealistic expectation for conservatives, such that when the 6 justices inevitably do not vote in a block in the coming terms, conservatives will lose the faith. Are there ways that committed originalists can combat this phenomenon by helping to reassure the base that the Originalist project has been worthwhile and originalist textualists can disagree in good faith? Very much related to our last discussion.
Well, look, occasionally people are conservatives, and I say that with political, not judicial conservatives, are not always going to like the results that come out. They're occasionally going to be disappointed. You saw that clearly with Justice Gorsuch in Bostock. You saw that with the chief in June Medical and the 2 Obamacare cases. Look, even Justice Scalia wrote an opinion that most people consider to be horrible from the standpoint of religious liberty, and the Employment Division versus Smith. I wouldn't give up on Justice Scalia, and I won't give up on Neil Gorsuch either. The chief in close cases, I waver a little bit. Yeah, look, it was after Bostock that all of a sudden you started seeing articles and tweets saying attacking the Federalist Society, attacking the Heritage Foundation, abandon originalism. It hasn't worked. As I say, you're not always going to get results that you like, even from judges and justices whom you like and admire greatly. But I think now with Justice Barrett on the court, things are looking up. I wouldn't give up yet.
Things are definitely looking up. I mean, but we've got to stick with originalism because it's the right methodology and there's a constitutional basis for it and we're doing the right thing. And I mean, if people's hopes are in the Supreme Court, they're just going to always be dashed. So I think we just, too much is being done at the federal level. Within the federal level, too many big issues are being kicked to the court and have been in past decades. And, we just have to think more broadly about, I think, how to try to all get back to a better constitutional balance of power where we're not hinging so many hopes on 9 people.
I also would just say, so I agree with that completely. And I would just say, I think that the divisions, not all the time, but often are overblown, and that there are political reasons for people to overblow them, right? There are lots of people who have incentives to try to create divisions in a political party, right? If you have people infighting, they're throwing less mud at you and more mud at each other. And so, it's important to look to, as Jen said, to stick to the constitutional principles, regardless of the outcome, because if you have those principles and then you win the intellectual argument, people understand that. as we saw at Justice Barrett's, confirmation, where I think she gave such a great explanation of originalism and why it was important.
Yeah. Okay, let's see. I have a question. This might be our last question from Frank Garrison. Following up on John's point about this far but no further, which Chief Justice Roberts applied to the Commerce Clause holding in NFIB, would that apply to amendments to existing statutes or just new legislation? For example, if Congress amended the Clean Air Act in a way that would violate the Constitution's original meaning, but would be upheld under Wickard, which view should the court apply?
Again, I'm in the Justice Thomas bolder, category most of the time, and I think that you should try to get it right. I mean, we have federalism. It was enshrined into our Constitution. Granted, we had a civil war and the 14th Amendment that sort of changed that balance, but federalism exists for a reason. So if there are Commerce Clause challenges or non-delegation challenges, I would, or other, perhaps under the General Welfare Clause, I would take those seriously. And it means that more power gets left to the people or thrown to the states. So be it.
I think this point has been made many times, but precedent is not, it does not always, should not always govern, right? If the Supreme Court were following precedent, Brown v. Board would never have overruled Plessy v. Ferguson. There is a time when, it is appropriate to discard old, bad, or wrong precedent. And the question is, when and how often does that happen? And I think you're gonna see those questions, but maybe not, they don't come up all the time, right? There's maybe a few cases a term.
Yeah, I think that's right. And I think the court, might do that more sometimes than it takes credit for, because maybe the people writing the opinion are trying very hard to suggest that they're not veering away from principle. But earlier this afternoon, I was on a panel looking at appointments and removal. And if you look at the removal cases in particular with the court recently, even with Sela Law, the court is trying to sort of not sign on to what it's terming new, unique ways of undermining presidential supervision. And so it's sort of reinterpreting past precedent. All of a sudden, Morrison's not overruled, but it becomes a narrow exception to the principle that the president has to have supervision over the executive branch. So I think the court, hopefully, and I think it should do the right thing and reach the right answer in certain cases. It might descriptively tell us that it's sticking with precedent, but be narrowing it sort of behind the scenes. And, hopefully it will at least do the right thing. Maybe eventually we'll also be more comfortable, even if that means directly having to contradict past precedent in certain cases where it's warranted.
I think that pretty much brings us to the end of our panel. Thank you to Jen and John and Beth for joining us. This was a really, really interesting discussion. And thanks again to the Federalist Society for hosting this great conference.
Thanks, everyone.
Thank you very much, Judge Rao.